Hello, this is the second part of chapter 20. We're going to talk about how you can own property with more than one owner and bailments, and then just a short, up-to-date kind of thing on the questions that I put about the scenarios that are online. All right, so we left off last time talking about what happens to abandoned or lost property. And so now we're going into the different ways that you can own property. You can own it all by yourself. There's no question you can own it by yourself. If you own it by yourself, you own it in severalty. And so if you ever happen to look at a lawsuit or claim of a creditor, you might see that the people that they're suing or the people that have signed the loan agreement have signed jointly and severally. Severally means by yourself. It's individually, that's you. Jointly is kind of what we're going to talk about now. Okay, when you own real property with someone else, or excuse me, not real property, any kind of property. When you own property with someone else, and that's absolutely allowed, we are going to talk about owning it as tenants in common, as a joint tenant, as a tenant by the entireties, or briefly, community property. Okay, a tenant in common means that I'm going to pretend like this just applies to two people who own it 50-50. That's not true. These could be, you could own it 1,000 people. You could own it all different ways and different divisions. But in order for me just to briefly go over the highlights of what we're talking about here, I'm going to pretend that we're only talking about two people and that they each have an equal share. But keep in mind that these rules apply even if you have more than two owners, and even if they don't divide it 50-50. So a tenant in common is when you own property with someone else and you each own a specified interest in that property. So let's say that you and I owned property as tenants in common and we each owned 50% of it. That 50% is ours. And that means that if I was to die, my heirs would get my 50%. You wouldn't be able to complain about it. Well, you could complain about it, but there's not much you can do about it in terms of ownership of this property. My heirs are going to come in, and my heirs are now going to own it with you. It can also mean that since that's my share, if I have a debt and I don't pay my debts, and my creditors decide to come after me, and they get a judgment against me, and I still don't pay my debts, they can come after my interest in that property. And you're going to be stuck because you still own 50% of that property, but you can't stop my creditors from coming after my share. So when you own property as tenants in common, you have to understand that you have your share, the other person has their share, and creditors can come in, heirs can come in, and you may not have anything to say about that. Okay, a joint tenancy is a little bit different because a joint tenancy has a right of survivorship. And usually the phrase that you will see is Mary and John own the property as joint tenants with full rights of survivorship and not as tenants in common. This means that if you and I own property as joint tenants with rights of survivorship, if I died, you would own the property. If you died, I would own the property. It's whoever survives the other then owns the property. Now there is a way, if one party had a creditor and they don't get paid and they have a judgment and they come after you and they're trying to collect, they may be able to break up the joint tenancy, and they may be able to get a court to decide what your interest is and give it to me. But the real issue with the joint tenancy is this rights of survivorship, that it goes to whoever is the last person standing. Tenants in common is a kind of a type of joint tenancy. It's a very old way of owning property. It's probably unconstitutional now, but it has not been found to be that way, at least not that I can see anywhere. It's a protection, which is originally why it was started, was as a protection for an innocent spouse. And when this started, the innocent spouse was always the wife. And it was a joint tenancy, you own property, husband and wife. It only applies to marriages. You have to be legally married. And this was one of these things when the Supreme Court approved basically same-sex marriages, that this had a lot more implications than just same-sex marriage. There's here, in order to be a tenant by the entireties, you have to be legally married. Each state has to accept marriages from other states. And so even if you were in a state that did not want to accept that, now probably you're going to have to. So tenancy by the entireties is for a married couple. It means that a creditor cannot take the property unless both of the owners owe the debt. That's one of the reasons why it's not a violation of the Fair Debt Collection Act in Michigan when you're loaning money to somebody to ask them for their marital status if they got a house, because that may affect your decision whether or not you would lend them money. Because their only asset may be their house. If they own it as a tenant by the entireties and you're the creditor, you may not be able to touch that. You may not be able to break up that tenancy by the entireties. As I said, it was originally designed as a protection so that the wife and children would have a place to live even if the husband, in maybe gambling debts, gambled away, you probably heard the phrase bet the farm, gambled away the property, they would have a place to stay and to live. And so it was originally designed as a protection. It was a protection against creditors and only for married couples. It is a form of joint tenancy. In other words, if you own, and it's presumed as for a husband and wife, you own it in Michigan as tenants by the entireties. There's only a few states that still have this. Michigan is one of them. That if one husband dies, wife gets the property. If wife dies, husband gets the property. The only person or the only group that can break this up is the IRS. The IRS can break up a tenancy by the entireties, but they do have to give the innocent spouse, assuming there is an innocent spouse. If there is an innocent spouse who did not know that the debts weren't being paid to IRS or whatever, then they can put a lien on the house, but they can't take it as long as that spouse still has an interest in it, the innocent spouse. It's probably not going to last too much longer, but at least from what I'm checking, it hasn't gone away completely yet. All right, and then community property. Community property is not really something that was in the common law that we follow, which is more the coming from the Great Britain and the United Kingdom. That's where the tenants in common, joint tenants, tenancy to the entireties comes from. Community property was more of a Spanish origin, so you are more likely to see community property states being states out west that followed more of the Spanish tradition. Community property says that any property that you acquire during the marriage, and again, a lot of these things were set up as protections in marriage, that since we have a public policy that favors marriage, that they were set up for that any property acquired during the marriage, even if it's only acquired in the name of the husband or the name of the wife, unless you can show that it was purchased or bought or whatever with assets that you had before the marriage, if it's acquired within the marriage, it's community property. It's property of both parties. Okay, so let's talk about bailments now. And bailments is in this chapter, and again, when we begin the next chapter and talk about warehousing and carriers, it is in that chapter also. So whatever you learn or talk about for this one is going to carry over to the next one. All right? A bailment it's a relationship between two parties where one party has the title, one party has the ownership, and the other party has possession of personal property. All right? An example of a bailment is when you take your clothes to the dry cleaners. You own your clothes. You take them into the dry cleaners. You expect that after a certain period of time, you pay your bill, they're going to give you back your clothes. They're going to give you back the same ones that you took in. Because you are giving them possession, you're giving them possession for a reason, you want them cleaned, and that you expect to be able to come back and get them. You are not giving them ownership. You are not giving them title. And that's what a bailment is. It's a relationship where one person delivers possession of personal property under an agreement, and the person that you're giving them to is under then a duty to return the property when everything in the agreement is fulfilled. Okay? So, what do you need to create a bailment? You first of all need an agreement. And by the way, we're talking about personal property here. Real property cannot be bailed. So anything that would come under our definition of real property, buildings, houses, rights in the land of another, those can't be bailments. Okay? So you need an agreement. You need an agreement with the other party. And always remember, this is the law we're talking about. You also have to be able to prove this, but that's a separate issue. Okay? So you have the agreement that you are going to give them possession. They're going to hold it for you. They're going to do something to it while they have it, whatever. And then at some point in time, you are going to come back, fulfill your part of the obligation, pay the bill, and that you're going to get it back. Okay? So you have to have that agreement. You got to be able to prove that. Then you have to prove, and some of these words we've talked about now in a lot of the chapters, they should be becoming somewhat familiar to you. Agreement should be familiar to you by now. And then these next ones, we're going to talk about delivery and acceptance. These should also be at least somewhat familiar to you now. Delivery means you've got to give it to them. If you don't deliver possession, then you haven't bailed anything. So you have got to deliver it to the other person. And they have to accept it. You can't just leave it on their doorstep. They don't know anything about it. They had no idea that you were doing this kind of thing. So you leave it on your doorstep, and then later on you just go, oh yeah, I left that at your doorstep, and they're going, I didn't know that. So there has to be a delivery, and then there has to be acceptance of that delivery in order to create legal, legitimate, and enforceable bailment. Okay? Now the person who is going to get the stuff is the bailee, and they only get possession. That's all they're going to have is possession, not title. Okay? And it will not pass to them. And the bailee can't sell the property. Now, there are some exceptions to that rule. This is law, there's exceptions to every rule, but the general rule is title will never pass to the bailee, and the bailee can't sell the property. Okay, renting space is not a bailment. So and if you rent a locker, you rent whatever, that is not a bailment, okay? You are not renting, you're not getting possession, it doesn't create any kind of bailment issues. All right, so let's say that we have the bailee, and there was an agreement, there was delivery, there was acceptance. All right, now the bailee, the person who has accepted possession, is under a duty to care for the property that they have had come into their possession. They have to take at least some steps to make sure that they are taking care of that property, because of course when you come back and you fulfill your obligations, you're going to be looking to get that property back. So it has to be there, and it has to be in the condition that you delivered it in, or like in the dry cleaners, it's got to be cleaned. but it's gotta be there, and they have a duty of care. So remember, you've heard the term duty of care before. Duty of care came up in the chapter when we were talking about the torts and negligence. And the first thing that you have to establish when you are bringing a negligence action is that there was a duty of care. Well, a bailee has a duty of care to take care of the goods that have been put into their possession. All right? But let's say that you are the bailor, you're the person who had title, who delivered the goods to the bailee who has possession. You're the one who has title to the goods. You have to prove that the bailee was at fault. You know they have this burden of proof. You know they have this duty of care. Now you have to prove they did something wrong. And then, of course, you have to prove that what they did wrong was what caused your harm. And that the goods that you went back to pick up are not in the condition that you took them in, there's something wrong with them, they're gone, they were stolen, whatever. And it's a negligence action. You have your duty of care, then you gotta prove that they breached the duty of care, and then you've gotta prove that was the proximate cause of the harm that you suffered. And it's the same when someone becomes a bailee. That's what you have to prove if you are alleging that they did something wrong. Now, it is possible to limit that in your contract. Now, some places have statutes, some places have ordinances about how much you can limit your liability. In any case, if you're limiting your liability, the bailee must give notice when they're taking the goods. When they're accepting them, they got delivery and they're accepting them, they have to, at that point, notice has to be given to the other party that they're limiting their liability. If any of you have ever gone to a banquet hall or a wedding, a reception, whatever, and it's wintertime in Michigan and you check your coat, you'll notice that where the place where you go to check your coat will have a sign somewhere saying that they don't accept responsibility for anything that happens to your coat. They're not going to be responsible for the money you leave in the pocket or your car keys if you leave them in the pocket, that they're not going to be liable for any of those kinds of damages. You almost always see those kinds of signs. And a lot of times people find these and they don't even know that they've agreed. I put something online, and it's a very small little thing that it'll be online, but this came as part of I got tickets, taking my grandchildren to a show at the Fox, and you print out your tickets. And it's, of course, a big piece of paper. It's a piece of paper just like this. And this is the small corner down in the bottom in very small type compared to the rest of it. And one of the things it talks about is bailment. It also has a lot of the other examples of things that we've talked about in contracts. And so I'm just going to go over this briefly right now in here. I'd like you to read this one online though, because it really does talk about several of the things that we've mentioned before. And I know it's small, but it's there. Okay? First of all, it starts out in big print. And remember what I told you, anytime you see big print, you need to read it, because usually what it is taking away some rights that you have. And this one starts off saying, this contract limits our liability. Read it. Okay? I'm willing to bet that almost everybody looks at their ticket that they print out. They look to make sure it's the right show or concert. They look to make sure it's the right place and time and all that kind of thing. And they never read all the, it looks like advertisements mostly. They never read any of the stuff that's on the bottom of the rest of the page. This is one of those things that you might want to read. It starts off, the customer and the company agree. You're going to see that word agree in lots of different contract things that you have. Because remember, that starts off a contract. It starts off a bailment. You have to agree. But in this case, at the customer's sole risk, the customer may park a vehicle in an unoccupied space. I'm not too sure how many people park their vehicles in occupied spaces, but that's what it says. And then subject to the following conditions. You've got to take everything out of the car. You must set the handbrake. If I hadn't read this, I never set my handbrake when I take them in one of those places. Never occurred to me that that was going to avoid any problems that I might have later on if I didn't have my brake set. I never do that. But anyway, obviously I've agreed to do it. You agree to inspect the vehicle before you leave the lot, all right? And then it talks about when you're gonna claim if you find damages or anything. And then in big letters in the middle of the page, again in big letters, it says company is not responsible for any articles left in your car, nor will the company accept possession or bailment of such articles. Attendant has no authority to bind the company or to create a bailment for such articles. These are the things that are in your car. Not necessarily your car, but the things that are in your car. They're not accepting a bailment for that. All right? In big letters again, further on, company is not responsible for loss of use or consequential damages. That was in the last section that we just read. It'll be in the last chapter when we get chapter 26 too. We'll be talking again about consequential damages. They're saying, you park here, you've agreed, we don't owe consequential damages. The total liability of the company to the customer is $250 for all damage or loss. This contract is not assignable. This is the entire contract, and no employee can modify it. And customer waives all rights that are in conflict with the foregoing. This little square of paper that most people, I'm sure, don't even look at probably has something in it that hits every single chapter that we have talked about up to this point. It's not much, but it is definitely powerful. That's why I'm saying, read the things that you are signing or you're doing or you're getting, because they are affecting your rights. Okay, that's the end of this chapter. I will pick up the next chapter next time. This one will go online on the 1st of April. The next one, Legal Aspects of Supply Chain Management, will be there the following Monday, April 6th. All right, so I want to talk just for a moment to make sure that you all understand what I've been putting on writing on Canvas. And that is, I'm still getting a lot of questions about how to submit things back to me. I've had in the past, I've had some difficulties getting assignments that got submitted through Canvas. So I said, I'm not going to do it this time because I've got 30 of you to get assignments from. So what I ask that you do is type it out or write it out, as long as it's legible. If you're handwriting it, make sure it's legible. And then send it back to me as a document with an email. Send it to my Macomb email address, which is dominkem@macomb.edu. Most of you have been doing that just fine. The reviews came in just fine. If you're not able to do it on the computer, or you're not able to figure out how to send it back to me, take a picture of it with your phone, send me the picture back. I just have to have something that I'm able to read. Now I've started going through your tests that were turned in, that were due Monday. It's gonna take me a little while to go through these. I'm not used to grading tests online, and I don't even have enough ink to print them all out. So it's gonna take me just a little bit of time to get them, and I have to grade all of them before I can give you your final grade, because it depends who gets the highest score, how many points you're gonna get. So if you work with me, it's easier. If you have questions, you can call me. I have all of your numbers in my phone now, so I know who it is that's calling me. If it's just not a convenient time for me, I'll call you back later. Otherwise, I'll take the call. All right, the small claim scenarios are on there. There's 3 of them. What I want you to do, and these would have been ones we would have done in class, but obviously we can't do that. So we have to modify it. We have to be flexible. So pick one that you might like to work with. And you, when it says you in the scenarios, it means you, the student. You are, and for example, in the first one, you own a small tattoo parlor in Michigan. You are the owner of the small tattoo parlor. You have a problem. I'm going to be asking you questions that tell me, okay, you know you have this problem. Some of them I'm going to have to figure out if you know what problem you have. What are you going to do about it? If you were this small business, it's going to be a lot of money to you. How would you go to court and get it back? How would you get a judgment, so that you might be able to collect some of this money. So for example, in the tattoo parlor, you have a dissatisfied customer. How are you gonna show that you are right, they are wrong? We don't always in this class assume that the customers are correct. So that's what you're gonna have to show me. And the questions are going to come in. The first one is gonna go, what are you gonna prove? The second set of questions is gonna be about what evidence or witnesses, I may switch those back and forth yet. What witnesses would you use? And remember, you have to have an expert witness in this. I'm trying to stick as close to the original assignment as we had. So you're gonna have to have an expert witness. You're gonna have to try and look at this and decide, okay, what kind of an expert witness do I need? And remember, an expert witness is anybody who assists the trier of fact. Doesn't have to have a PhD, doesn't have to have published articles. They just have to be someone who has more knowledge than the average person might have. And so you try to figure out, who you would want as a witness, what types of witnesses you would want. And then the last one will be evidence. And you need a paper exhibit and you need a physical exhibit. And what I'm going to have you do is draw me or send me a picture or whatever of the physical exhibit that you have made that you would show me in one of these things. And that'll, I think, become a little plainer as we go through this assignment. But we'll be doing this over the next 4 weeks, and then at the end, I'm going to call you all individually at this point, unless maybe we can set up something on Zoom. I'm going to call each one of you individually and talk for a little bit about what you did for this project. If you have questions, email them to me and I will get back with you. I've been trying to get back with people as soon as I can. Just please be understanding and realize that it's maybe the same question I'm answering over and over, and in class I can just tell you once and you all know the answer. This way I have to do it individually, so it's taking just a bit longer. Thank you for your cooperation up to this point, and as soon as I get your test done, I'll put them online.